I've watched a lot of people walk into this courtroom believing they were the smartest person in the room, but nothing prepared me for the morning Diane Marsh sat down at that defense table, heard 38 months of deliberate financial theft read into the record, and sighed. Not nervously, not involuntarily. She sighed the way someone sighs when a meeting is running longer than it should. And when I asked her a direct question about the woman whose payroll she had nearly destroyed, not a legal question, not a procedural question, a human question, she told me calmly and precisely and to my face that the question was emotionally manipulative. What happened in the next 20 minutes proved something I have believed for 30 years on this bench. You can walk into this room wearing composure like a coat. You can have it fitted, practiced, and convincing enough to work in every other room you have ever been in, but this room sees what is underneath it. And what was underneath Diane Marsh's composure that morning was the thing that sealed every word of her sentence. If you believe that calling accountability manipulative is itself the most revealing thing a defendant can do in a courtroom, stay for every word of this story. Because what I did next is exactly what this bench is built for. The file on my desk that morning described 38 months of financial misconduct across a single organization. Fraud, theft, and systematic falsification of expense records totaling $127,000, redirected from the reimbursement accounts of 11 small business owners and independent contractors into a personal account built specifically to receive it. The methodology had been constructed to stay below every automatic audit threshold the company system contained. It had worked for 38 months. It had stopped working because one person had been doing her job carefully enough to notice a routing number that didn't belong. Diane Marsh entered the courtroom in a fitted charcoal blazer over a silk blouse, moving with the practiced composure of someone who has spent a decade in rooms where her job was to manage how things were perceived. Her posture was controlled. Her expression had been arranged with care. She took her seat at the defense table without looking at the bench, and her attorney, a well-regarded white-collar defense specialist who has appeared before this bench on 3 previous occasions, opened his document folio with the specific efficiency of someone who believes the morning will be manageable. Diane glanced at the gallery briefly without interest. She found nothing there that required her attention and looked back at the table. What she had looked past: Patricia Owens, second row, 58 years old, Director of Internal Accounts, 31 years of financial compliance work, which is 31 years of doing the kind of careful, unglamorous, detail-level work that finds things other people miss. Patricia had found this. She had spent 6 weeks building the documentation before she brought it to legal counsel. She was sitting with her hands folded and her expression completely steady. And Grace Tanner, third row, gray blazer. She had come alone. She had been waiting 7 months. Diane had not looked at either of them. She looked at this courtroom the way someone looks at a room they have already decided they know how to handle. Diane's attorney rose and presented the defense framework with the polished efficiency of someone who has spent a career learning how to make systematic financial misconduct sound like a private struggle that got out of hand. His client, he explained, had been operating under extraordinary personal financial pressure, a combination of compounding circumstances that had led over time to decisions she deeply regrets. He spoke of her 10 years of exemplary service to Hale Capital Group, her consistently positive performance reviews, the trust she had earned and maintained across a decade of professional responsibility. He noted that she had already offered full restitution and characterized the charges as an appropriate subject for a negotiated resolution. He was measured, practiced, and delivering the specific argument of someone who has learned that the most effective framing of deliberate financial misconduct is to make it sound like an overwhelmed person making a series of private mistakes rather than a systematic actor making a series of calculated decisions. I listened to every word. Then I asked my first question. Counsel, your client's offer of full restitution, when was that offer made? Following the charges being filed, he confirmed. I asked whether any restitution had been offered or any attempt at restitution made in the 7 months between the discovery of the misconduct and the filing of charges. He recalibrated. No, he said, not formally. I asked my third question. The forensic audit documents a system of constructed routing numbers, manipulated authorization timestamps, and calibrated processing intervals, built over more than 3 years. Can you help this court understand how extraordinary personal financial pressure produces that specific architecture rather than a series of discrete decisions? The attorney began a response about habitual compensatory behavior and how financial stress can produce patterns over time. I said, "Counsel, what I am describing is not a habit. What I am describing is an architecture. There is a difference." Then I asked to have the forensic audit entered into evidence. I read 3 passages aloud, not the summary, not the conclusions. The 3 passages that described in the forensic accountant's own technical language how the system had been built and how it had been operated. The first passage described the construction of the false vendor routing numbers. Each one had been registered to a shell account that processed through 2 intermediate processes before reaching its destination, a structure that created sufficient transactional distance to prevent any single-step audit from identifying the origin and the endpoint as the same person. The second passage described the authorization timestamp manipulation. Approvals had been logged during high-volume processing periods, specifically the 3 days following monthly billing cycles, when the volume of legitimate transactions through the system was highest and secondary review was statistically least likely to be triggered. The timing had been consistent across 30...
I've watched hundreds of people walk into a courtroom believing they understood the room better than anyone else in it. They come in prepared, composed, controlled, convinced that if they say the right things, hold the right posture, and maintain the right tone, they can shape what happens next. But nothing in 30 years on the bench prepared me for the morning Diane Marsh sat down at that defense table, listened to 38 months of deliberate financial misconduct being read into the record, and sighed. Not nervously, not by accident. She sighed the way someone does when a meeting is running longer than expected, the kind of sigh that doesn't come from fear, but from mild inconvenience. And in that moment, before a single word of defense had even been presented, I understood something important about what we were about to see. The file in front of me documented 38 months of activity. Not chaos, not confusion. Activity. Structured, repeated, sustained. Fraud, theft, systematic falsification of financial records. A total of $127,000 redirected, quietly, consistently, from 11 small business owners and independent contractors into a personal account that had been built for one purpose: to receive money that did not belong to it. This wasn't opportunistic. This wasn't reactive. This was constructed. The system had been designed to avoid detection at every level. Each transaction was deliberately kept below the threshold that would trigger an automatic audit. The timing of approvals wasn't random. They were logged during peak processing windows, when legitimate transactions flooded the system and oversight was statistically weakest. Even the routing structure itself had been engineered. Funds didn't move directly. They passed through layered accounts, creating distance between source and destination, just enough to avoid raising suspicion. And when the company updated its internal safeguards, the system didn't break. It adapted. Twice. That is not the behavior of someone overwhelmed. That is the behavior of someone in control. And yet, none of it would have been discovered if one person hadn't been doing her job carefully. Patricia Owens, 31 years in financial compliance. No spotlight, no recognition, just quiet, consistent attention to detail. She noticed something small, a routing number that didn't belong. And instead of ignoring it, she followed it. For 6 weeks, she built the documentation herself, piece by piece, transaction by transaction, until what she had wasn't a suspicion anymore. It was proof. She was sitting in the second row that morning, hands folded, expression steady. She didn't need to say anything. Her work was already speaking. A few seats behind her sat Grace Tanner. Gray blazer. No legal team. No entourage. Just a small business owner who had been waiting 7 months for this hearing. Her company had submitted legitimate reimbursement expenses, over $31,000. That money had been redirected. And for a time, her business had come close to missing payroll. Diane Marsh didn't look at her, didn't acknowledge her, Didn't even register that she was in the room. She looked at the courtroom the way someone looks at a space they believe they already understand. Her attorney stood and delivered a polished, familiar argument. Pressure, personal hardship, a respected career, a lapse in judgment. He spoke about 10 years of trusted service, strong performance reviews, a person who had lost her way under difficult circumstances. And he emphasized restitution. An offer had been made. Steps were being taken. This, he suggested, was something that could be resolved. So, I asked a simple question. When was restitution first offered? After charges were filed, he answered. And before that? I asked. There was a pause. No. Then I asked something more important. The audit describes a system, routing structures, timing patterns, transaction calibration, built and maintained over 3 years. I looked directly at him. Help me understand how pressure creates that. He began explaining patterns of behavior, how stress can lead to repeated decisions. I stopped him. That's not a pattern, I said. That's architecture. I had the forensic audit entered into the record. And instead of summarizing it, I read it. 3 passages. The first described how false routing numbers were constructed and layered to conceal origin. The second detailed how approvals were deliberately timed to coincide with peak transaction periods. The third explained how transaction amounts and intervals were calibrated, adjusted over time to stay invisible within the system. I read every word slowly, clearly, without commentary. When I finished, the courtroom was completely silent. And Diane Marsh? She didn't react. Not with concern. Not with reflection. She maintained the same composed expression, as if what she had just heard was simply a version of events she didn't agree with. And then, she sighed again. That's when I asked her directly. Not as a judge speaking to a defendant, but as one human being asking another. Did you know that the money you redirected belonged to a business that employed people? Her attorney reached for her arm. She looked at his hand, then at me. And she chose to answer. Calm. Measured. Controlled. She said the question was inappropriate. Emotionally manipulative. Not relevant to the legal matter at hand. That was the moment the room changed. Because in that single statement, she didn't just respond to a question. She revealed how she understood everything that was happening around her. I let the silence sit for a moment. Then I spoke. You sighed while listening to evidence of a system you built over 38 months. You described a question about real harm as manipulation. And you framed this proceeding as something performative. I paused. You are not managing a room. Her attorney tried to intervene. He sat down before finishing his sentence. Because there are moments in a courtroom when everyone present understands that the outcome is no longer uncertain. This was one of those moments. The verdict was delivered. Guilty on all counts. And the sentence followed. Not symbolic. Not flexible. Specific. 18 months in a state correctional facility. No early release consideration for the first 12 months. Full restitution, $127,000, paid under court supervision. 5 years of monitored probation. A permanent restriction from financial authority roles during that period. And written apologies, reviewed by the court before delivery, to every person affected. Her attorney called it excessive. But it wasn't. Because this wasn't about a mistake. It was about something built, maintained, refined, trusted to remain hidden. As she was being escorted out, her composure finally broke, but not in reflection. In frustration. This will reach Conrad, she said.